This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Ms. Lindsay. And on behalf of Judge Bennett and Judge McBrayer, we are pleased to welcome the appellant, Mr. Ayers, and all counsel for this oral argument, which we are both recording and broadcasting by live stream over the YouTube channel so that we may fulfill our obligation to maintain open courts. We will conduct the hearing in the same manner as if we were all together in the courtroom. Mr. Ayers has 15 minutes to present his opening statement and his rebuttal, and thus he will reserve some of that 15 minutes for his rebuttal, and I understand that's already been designated. Now, the appellees, there are 5 of them that intend to argue. Just one simple question: have you agreed as to how many minutes each will argue? Ms. Lindsay says yes, and unless somebody speaks up to the contrary, we'll let Ms. Lindsay program the clock. All right, Ms. Lindsay, call the case. James
G. Akers versus Gregory Funding, LLC et al.
Very good. Thank you, Mr. Ayers. Mr. Akers, forgive me. You have the floor, and there will be a clock that says you have 10 minutes at the present time, and then after that's expired, we'll hear from the attorneys, and then we will come back to you for your rebuttal. So please unmute your microphone and proceed.
As far as
I can
unmute it, I'm not.
I can hear you. Thank you.
All right. Okay. Well, really, the entire case comes down to this issue here. All the appellees here will argue that the case was heard and adjudicated on the merits, which is not the case at all. The trial court, basically ruled, as all the attorneys for the appellees argued, that the complaint was incomprehensible. This was never heard by any means on the merits. I have a video that was provided by the court system. And it shows where I've had several stacks of papers, which I was prepared to argue, but and went to court that day on the 31st of August, 2019, to open my opening statement. Was want to continue where we were the last hearing, which was the motions for default judgment. There should have been at least 4, maybe 5 default judgments right at the very beginning here. But anyway, I got no chance to even argue this at all because Judge McClendon says, I don't remember that, and made it very clear she didn't want to hear any more about it. So then they proceed to make their arguments that this entire complaint was incomprehensible, so that was their basis for having it dismissed. Now, I would ask the court here, I would assume that all you appellate judges have read the complaint. I don't think see how they could possibly argue it's incomprehensible. It's in the same format that Tennessee law and federal law are written in, and if they can't understand my complaint, that apparently means they can't understand the laws of the Tennessee or the United States. So I would ask very simply, I don't know if it's proper to ask, but did any of the appellate judges have trouble comprehending the complaint?
We get to ask the questions, and you get to provide the answers.
All right. Well, anyway, so that's how the whole thing started out. And then it ended up with the court, Judge McClendon, dismissing the entire case, although the order had not been entered. So then I came back and dismissed the entire case based upon Tennessee Rule Civil Procedure 4101. And it's very clear about what it says. And there's a Tennessee Supreme Court case which says the same thing. Once the notice is given, then the case is closed. It doesn't give the judge an opportunity to go back and change it after that. Once the notice is given, then the rule says, and the law says, and the rules say that the clerk shall enter the order, which they did. The case was closed based upon my order. And then Judge McClendon comes back later on, issues new orders on top of the case was closed. I don't get it. I'm not a lawyer, but I do have a little bit of common sense. I don't get that at all. So anyway, 4101 says what it says. I dismissed the case. No reason why I couldn't have. In fact, I should have. So I don't understand what the argument is there. I guess, the laws should not be left open for interpretation. Then beyond that, I don't really have much else to say. My brief says all that I want to say, and I don't really have anything to add or deduct from it. So if the appellees don't want to do to make their arguments, that's fine. I'll do my best to react to that after they're completed. Thank you.
Thank you, Mr. Akers, and we will hear from each of the attorneys. And after all of them have had their say within the very limited amount of time they will have, we will come back to you so that you can address their any points they've made and anything else that you want to raise. And let me clarify what I said a moment ago. I should have prefaced my rather brief response by saying during oral argument, the judges, we ask the questions and the attorneys and the pro se litigants answer the questions. The reason I say that is because this gives us an opportunity to ask questions that are prompted by your briefs and the opposing party's briefs. So I apologize for my response if it seemed flippant. All right, who is going to argue first? And please abide by the short amount of time you will receive.
Your Honor, Gray Waldron on behalf of the appellee Gregory Funding, LLC. And it's Gregory's position that the only order that's presently before the court is the order denying the appellant's motion for reconciliation. And that reconciliation motion was styled a lot longer, but at the end, it's Gregory's position that the trial court did not abuse its discretion in denying the motion, and that is the standard that's before the court, is whether they abused their discretion. And it was appropriately denied under the standards of either Rule 59 or Rule 60. Motions for reconciliation are obviously not defined under Tennessee law, so it's got to be either a Rule 59 or Rule 60 motion. And the timing of the way the hearing that Mr. Akers has talked about, that was a hearing that was held in August of 2019, and two orders were entered from that. There was an oral ruling that the motion to dismiss on behalf of Gregory was granted, and we were to tender an order, which we did, and two orders were ultimately entered on the same day, September 19th of 2019, one at 9:28 a.m., and that was Gregory's order. It was a dismissal with prejudice, and then another at 10:06, and that was Mr. Akers' voluntary dismissal order. In the appellant's view, the relief provided in the Gregory order conflicts with his voluntary dismissal order, and that's presumably because Mr. Akers believes his effort to voluntarily dismiss the case after oral argument and an oral ruling on his motion vacates the effect of such a loss. That's simply inconsistent with Tennessee law. And this court in Irvin versus Greenwise Homes earlier this year was presented with the same fact scenario. A party went forward with a case, lost at oral argument, an oral ruling was made at the hearing, and then they attempted to tender a Rule 41 voluntary dismissal to avoid the effect of the loss. And the court correctly stated in Irvin that a plaintiff's right to voluntarily dismiss a case in a non-jury case lasts until the case has been finally submitted to the trial court for a decision. It cites to Weidman versus Hersey and Ewan versus Hardison Law Firm and Hamilton versus Cook, and answers the questions that are dispositive here. Whether at the time of the notice of voluntary non-suit was filed, the case had already been submitted to the trial court for a determination on the merits, and it has. And therefore, Mr. Akers no longer had a right, voluntary dismissal non-suit as a matter of right. It became discretionary. And then the second question that was addressed in Irvin was, if the Rule 41 right was now discretionary by the trial court, whether the trial court properly concluded that the other party would suffer plain legal prejudice if the voluntary dismissal was allowed. In applying that rule here, we see that his voluntary dismissal on the August 30th oral ruling, when he went forward with his argument and it was denied by oral ruling, that occurred on August 30th. His September 3rd is when the Rule 41 voluntary dismissal was tendered. Then the August 28th, 2020 order that's on appeal before this court does nothing more than elaborate on the correct reasoning of why the trial court did what it did. It entered two orders. One was dispositive of the claims against Gregory that were meritorious, and the voluntary non-suit that was discretionary at that point was granted, but it was granted with respect to the people that didn't have a vested right at that time. The Irvin opinion drew a distinction between the Hamilton decision and the Club LeConte versus Swan decision. And in Hamilton, you had a notice of non-suit that was filed, and plaintiffs had participated in a hearing on the defendant's motion to dismiss, similar to what they had here, and valid defenses were demonstrated. And the trial court already issued its oral ruling dismissing all claims against the defendants. So there was a vested right in Hamilton versus Club LeConte versus Swan, and that was the trial court had not yet ruled on the motion to dismiss when the Rule 41 was tendered, and therefore there's a different result. It wasn't the plaintiff had not lost their right as a matter of right, or their voluntary dismissal rights. Here, the Hamilton set of facts is present. Mr. Akers, again, he filed his Rule 41 notice on September 3rd, 2019. That was after the hearing on the motion to dismiss and the oral meritorious ruling made at such hearing. And that occurred again on August 30th, 2019. Mr. Akers relies on Lamont versus Lamont, and for the reasons cited in the brief, we believe that those are readily distinguishable. And with my time, I'll turn it over to the next appellee.
All right, the next appellee, please.
Good afternoon, Your Honors. May it please the court. John Roan on behalf of appellees Dyke O'Neill and Radian Services. Your Honors, before we substantively address the appeal, there's two preliminary factors to consider. First, this appeal is essentially moot as to Dyke and Radian, as their second position mortgage debt owed to Dyke was paid off in January of this year with a lien release recorded in March, and as the sections of the complaint pertaining to Dyke and Radian essentially only sought to preclude them from foreclosing. This mootness was noted in this court's recent ruling in case M 2021-00063 COA R3CV, which was an appeal by Mr. Akers from a chancery ruling in a case involving a complaint with virtually identical allegations to the trial court complaint. More specifically, paragraphs 14A through N of the trial court complaint are virtually identical to paragraphs 11A through S of his chancery court complaint. Secondly, and as alluded to by Mr. Waldron, this is not an appeal of the order granting Dyke and Radian's motion to dismiss. This is an appeal of the order denying Mr. Akers' motion to reconcile what he believes to be conflicting orders of the trial court. As this appeal was filed approximately 11 months after entry of the order granting Dyke and Radian's motion to dismiss, the time to appeal that order had passed long before initiation of this appeal. Under Tennessee Rules of Appellate Procedure 3A and 4A, Mr. Akers only had approximately 30 days thereafter to appeal that order, which would have been on or about November 13th of 2019. Other than an extraordinary appeal that was ultimately denied by the court in December of 2019, he failed to do so. Other than mootness, the ultimate issue on appeal is whether the trial court erred or abused its discretion in denying Mr. Akers' motion to reconcile the allegedly conflicting orders. Upon review, it's clear that they did not. Mr. Akers does not articulate any meaningful argument in favor of his position. He only includes bare reference to the Tennessee Rules of Civil Procedure and dicta pertaining to Rule 41.01. He appears to allude to his belief that he can dismiss without prejudice at any time, subject only to the exceptions set forth in Rule 41.01. Cases cited in our brief make clear that that right only exists until the matter is submitted to the court for ruling, however, and that's Weedman and Greenwise Homes. In the case at hand, Mr. Akers' notice of voluntary dismissal without prejudice was not filed until after Dyke and Radian's motion to dismiss was filed, heard, and orally granted by the trial court. After the August 30th, 2019 hearing and the oral ruling granting Dyke and Radian's motion to dismiss, they had a vested right to dismissal with prejudice. Excuse me one moment, please. Accordingly, the trial court recognized and upheld Dyke and Radian's vested right to dismissal after the August 30th, 2019 hearing. It's clear that they neither erred nor abused their discretion. Furthermore, to the extent that Mr. Akers persists with attempts to challenge the assignments of the deed of trust or raise issues pertaining to the mortgage debt owed to Dyke He lacks standing to do so, as he's neither an obligor on the note nor a party to any of the assignments of the deed of trust. He also fails to articulate any supposed unfair or deceptive acts by Dyker Radian under the Tennessee Consumer Protection Act, but as his complaint implied, that Dyker Radian were supposedly in violation of the act sometime around March 4th, 2009, which would have been around the time of the first assignment of the deed of trust. The applicable statute of limitation would have expired in March 2010, and in no event and later than March 2014, which is pursuant to Section 110 of the Act, well before he filed his complaint. Finally, Dyker Radian would also note that Mr. Akers' brief generally fails to articulate any meaningful argument as to them, any legal error by the trial court, and fails to identify any standard of review or relevant legal authority. Therefore, he's waived any such arguments. In light of the foregoing, it's respectfully our position that Mr. Akers' appeal is entirely without merit, and given the recitations in the appealed order, should be either dismissed as moot, given the payoff of Dyke, or that the appealed order should be affirmed on appeal. Thank you, Your Honors.
Thank you. And we'll now hear from the third appellee whose argument comes forth.
Good afternoon, Your Honor. Allison Stewart, and I am here today with my co-counsel, Mr. Caparella. We represent three of the appellees in this case: FV1, Morgan Stanley Mortgage Capital Holdings, and Saxon Mortgage Services. I know my time is limited, and my co-counsel has already covered the waterfront of the issues before the court today. So I will just add that the three entities that I represent are similarly situated in that they also moved to dismiss Mr. Akers' complaint, and their motion was successfully granted by the trial court back in 2019. Notably, Mr. Akers did appeal that decision to this court, and this court denied that application for extraordinary appeal also back in 2019. So to the extent Mr. Akers is attempting to sort of relitigate or reappeal that decision, the court's already addressed that issue. Again, as my co-counsel pointed out, the issue that's really pending before the court relates to the order denying the motion for reconciliation. It's our position that the trial court made the right decision in this case by denying that motion because the order dismissing the parties was already in place days before Mr. Akers filed his voluntary dismissal. So for those reasons, we're asking the court to affirm the trial court's decision.
Thank you, Ms. Stewart. Next.
Must be me. May it please the court, this is Houston Parks representing PNC Bank. First of all, we are relying upon a stipulation that we filed in the trial court, establishing first that Mr. Akers continues to mention the wrong party, an improper party, PNC Financial Services. There is no such party. PNC Bank National Association is the proper party. He's never named. The stipulation also states that my client, PNC Bank, did not acquire from a predecessor bank a loan that is the gist of Mr. Akers' lawsuit, a particular loan that my bank has no interest in. We tried to have an agreed order. We had an oral agreement. Mr. Akers backed out of that because he wanted language that was simply too broad and undefined for us to enter into.
All right. Thank you, Mr. Parks. And our final counsel.
Good afternoon, Your Honors. This is Lauren Roberts. I'm here on behalf of my client, Bank of America, and I am not sure that I have much to add beyond what has been previously stated by my co-counsel or co-defendant's counsel regarding the arguments made by Mr. Akers and the reason that we are here before the court today. Like the others, my client participated in the original case by filing a motion to dismiss, which was ruled upon. And like the others, it is our position the only matter before the court this afternoon would be Mr. Akers' motion for reconciliation. As we've argued in our brief, there is no reason for this court to come to a different conclusion than what was reached by the trial court on that motion for reconciliation. We'd ask for that ruling to be affirmed. And I'm happy to answer any questions Your Honor has, but otherwise we'll rest on our brief.
All right, thank you. And I believe that's all 5 of the appellees who wish to argue. Let me know if I've left somebody out. Not hearing any objection, we will now hear the rebuttal from Mr. Akers. You have 5 minutes.
Your Honor, first, I completely agree with PNC and Bank of America, except on one thing, and that is I used when I named them in the lawsuits, I used the name that was registered in the Secretary of State's office for each home state of those banks. So I don't know the issue of whether that's a proper name is just really silly, because if they don't like the name, they should change it to Secretary of State, not change it with me. Now, I agree with them also that I didn't really have a claim with either one. Neither Bank of America nor PNC I had no quarrel with either one of them. However, they both had encumbrances on my property, on the title of my property. All I asked them to do was remove it. All they needed to do was a simple statement that we have no interest in this property. Very simple. And that's what Mr. Parks, or PNC, tried to do, except they addressed only one case, and that was the PNC case, which was great. But, I mean, the Doc O'Neill case. But to leave out the other one, the case of Gregory funding, it was insufficient. I agreed to that, absolutely. But just to half the job is not sufficient. All they need to do is to rather go through all these procedures here. All either PNC Bank or Bank of America needed to do was say, we have no interest in this property. We never acquired the interest. We have never transferred the interest. It's that simple. Just one page with all they need to do. However, all this other stuff comes into play here, which there's no need for whatsoever. Now, back to Mr. Rome. He brought up a lot of issues that are not relevant to this appeal, and I'll address one of them right offhand. He says that this case is moot because his client, Doc O'Neill, and now allegedly Gregory funding has also been paid in full. There's a big difference between paid in full and extortion. They were both extortion, not paid in full. They were extortion. That's plain and clear, and that's a matter of currently under review in the federal court here in Nashville. But to say that they had a right to do that, my big quarrel here is the courts have made assumptions here based upon Mr. Rome's representations that his client never had. This client that had a right to enforce a lien, which they basically acquired a electronic copy of a deed of trust, and they enforced it. And here we are, over a year later, they still can't provide the original, which I asked for way back 5 years ago. They never had it. There's a big difference in fraud and satisfaction, and this is fraud. And the money they were paid was extortion. Now, to get back to the real issue here, I just want to straighten that out on Mr. Rome, because I know I'm very much familiar with him and his strategies. But my issue here, and I did timely appeal the original one within 30 days, the court's order, when she denied my voluntary dismissal. I did appeal that under Rule 40, like they're supposed to. This delay here, all this delay that took place. That's why we were waiting for the Court of Appeals to rule on the Rule 40 appeal. So, I mean, that was all done timely. If you go back and look at the record here, or anybody go back and look at the record, they can see it's all done timely. Period. Now, I didn't file my this appeal here until the ruling on the Rule 40 appeal had already been ruled on. And I have, and the court, even Mr. Hibner, I have correspondence from him who said that he realized there was a conflict between the two orders. Now, I'll go back to the very simple one here, and it's very simple. This is going back to the Rule 41 and the Lamont versus Lamont case. In sum, although an order is required to finally adjudicate the case, the UN decision makes clear that the filing of non-suit is the operative filing for determining whether a plaintiff is entitled to dismissal, without prejudice, not the filing of the order immediately dismissing the case. The non-suit actually occurs before the entry of the order. Now, I'm not a lawyer, but I can read, and I'm not maybe as smart as some of these lawyers. These lawyers probably know I'm not. But I can understand that much. I can comprehend that. Now, if they don't like the law, they should change it with the legislature, not with me. This law here is very clear. The Lamont case, the Tennessee Supreme Court case, is very, very clear. And I don't know how they twist it around to make it mean something else, but it says what it says. This case, this case should have been dismissed without prejudice. No, actually, it should have been 4 or 5. There should be 4 or 5. Shoot. Orders of shoot. What do you call that when somebody don't answer? I'm tired. I'm sorry.
Default. You're talking about a default judgment?
4 or 5 default judgments. There's no question about that. One of them being AGX, one of them being Shapiro and Engel. There's and Wheelhouse. There should have been 5 default judgments. The judge ignored.
Mr. Akers, your time is up. Do you want to give a short conclusory statement?
Yeah, very simply, the case is it was dismissed without prejudice, and it should remain so.
All right. Thank you, Mr. Akers. Thank you, Mr. Akers, for your argument and for that of the counsel, the 5 counsel who spoke on behalf of their clients. We will take this matter under advisement, and for Mr. Akers' benefit particularly, we will provide a written decision which will be delivered to all parties, including Mr. Akers and the counsel of record. Ms. Lindsay?
This Honorable Court of Appeals of Tennessee is in recess until 3 p.m.
Thank you, and all of you are free to exit this Zoom meeting.